Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking about alternatives to trial in an eviction matter. Let's get started. So for today's purposes, we are presuming the trial in your eviction is still in the justice court, which is the base level for any eviction. You file your original eviction in a Texas court, the justice of the peace in the county and the precinct where the rental property is located. And this is where the eviction process begins. And so why would there be a need for an alternative procedure to trial? Well, the main reason would be that your tenant has requested a jury trial, and that jury trial is months and months down the line, if it's even set at all. Some justice courts take several weeks, if not months, before they even set the matter for trial, because jury trials are so packed, so far behind. And so you probably need some alternative method for dealing with your eviction. The math is very simple. Every month that goes by, you are losing rent. And so if you've begun an eviction proceeding against a tenant for non-payment of rent, and you've begun it early, you're going to want to streamline the process in a way to minimize your losses. And one strategy for doing that, when your tenant has delayed the process by way of a jury demand, is through the motion for summary disposition. A motion for summary disposition is a procedure that's set up in the Texas Rules of Civil Procedure. And what they say is you as the plaintiff can file a motion if you can establish that there are no controvertible facts, nothing that the court otherwise, or in this case the jury, has to really siphon through. If the matter is simple, for example, a simple claim of unpaid rent. Months 1, 2, and 3 remain unpaid, and you can file a motion with an affidavit that states those things, where you swear to these facts. The court can review it outside of the jury and establish that nothing else is needed to be determined because the facts are uncontroverted. Now, uncontroverted isn't the exact standard. The defendant has an opportunity to raise an issue of fact that otherwise might have to be resolved with the jury. For example, if the tenant claims, no, I've made payments, but the landlord has not acknowledged these payments. And if there's some dispute as to payments that were made and there are fact issues for the court to have to resolve, well then unfortunately you cannot proceed on a motion for summary disposition. But if those facts simply don't exist, if in fact month 1 the tenant made no payment, made no effort to make a payment, and the same went on in 2 and month 3, then you can swear in an affidavit to these facts. And if the defendant has no adequate defense and there are no fact issues for the court to resolve, the court can, after 14 days, either set a hearing or on its own make a decision and sign a judgment in your favor. Naturally, this would dramatically speed up the process. And so the question is, can you do this on your own? You absolutely can. Should you contact an attorney? Naturally, I'm going to recommend that you do that. You're going to want to file your motion and make sure that it's filed properly. You're going to want to attach the proper exhibits, which in your case would likely be the lease, a copy of the notice to vacate, and a copy of an affidavit to the facts that we've just discussed. Now, once the court has reviewed these, again, a hearing can be set. Now, none of this is automatic, and so you'll have to file your motion and you'll file your exhibits, and you may have to request a specific hearing from the court. Different courts have different procedures as to how this is done. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. For your court, the court may on its own, when it comes to it, may set a hearing for you at a future date, and hopefully that future date is well in advance of the jury trial setting. For other courts, there are windows when the court will hear certain motions, and you and the court can decide what that particular date setting is. You'll give notice to the opposing party, or the court will send notice out to the opposing party at the time of that setting, and the both of you will attend the hearing. Now, in some cases, the court can decide the matter without the parties. And so it really is specific to your court. So if you have questions about it, you can contact the court and get some basic information about the procedures of a motion for summary disposition from the court. However, you are strongly encouraged to seek out legal advice from a landlord-tenant attorney in your area who you know and trust. And if you are interested in contacting our office and maybe just having a consultation to discuss the possibility of a motion for summary disposition, you're free to do that. Our number is here on the bottom of the screen. Additionally, if you're interested in hiring counsel, we're available for that all over the state of Texas. But if you're in a situation where your tenant is stalling the eviction process with a jury demand in particular, or some other procedure where the trial itself is way in advance, it's sometimes recommended that a motion for summary judgment is a direct and easy access to a judgment outside of the purview of the jury. Now, naturally, we cannot guarantee that your hearing for a motion for summary judgment will be granted. We cannot guarantee that it'll actually be heard prior to a jury trial setting, nor can we agree that the judge is going to grant it based on even the best of evidence. But it is worth a shot if you know that your jury trial is months ahead or hasn't been set yet. You may want to draft and file a proper motion for summary disposition so that your case can be heard well in advance of some distant jury trial setting.